So, you know that whole child custody thing can be quite a roller coaster, right? Well, today we're buckling up and riding into the thrilling world of child custody, with a special focus on what happens when one parent decides to pull up stakes and hit the road to a new state. Sounds like a storyline from a soap opera, but believe it or not, it's a reality for many. Buckle up! We're simplifying the legalese. First, let's get clear on what we mean by relocation. Picture this. You're the parent who spends the most time with your child. That's called the custodial parent. And you've decided to move for a new job, better financial opportunities, or personal reasons. This shift can cause a hiccup in the visitation schedule for the other parent, the non-custodial one. And to avoid drama, child custody agreements usually have a clause about moving. If the non-custodial parent finds out about the move, they should hightail it to family court ASAP to try to stop it. We'll touch on timelines in a bit, but the sooner the better. If you head to court before the move, it may be put on hold until a hearing is held. If you go after, depending on timing, the judge might require the custodial parent to return pending a hearing. Now, listen up, dads. Moms don't have the upper hand here and can't just decide to move. A lot of dads think that moms can relocate at will and that they, as fathers, don't have a say. That's a myth, gents. So, how does the court decide? It boils down to what's best for the child. The court weighs several factors: why each parent does or doesn't want to move, the relationship between the child and each parent, the potential impact of the move on the child's relationship with the non-custodial parent and siblings, potential benefits of the move, and the feasibility of maintaining a good relationship between the child and the non-custodial parent post-move. The Uniform Child Custody Jurisdiction Enforcement Act, UCCJEA. This law is followed by all U.S. states and prevents conflicts between states over jurisdiction in child custody cases. Under the UCCJEA, the child's home state, where the child has lived with a parent for at least 6 consecutive months prior to the legal action, takes precedence. This prevents one parent from running to another state to file a custody petition, forcing the non-custodial parent to travel to assert their rights. But remember, the 6-month clock is ticking. Often we're asked, isn't it kidnapping if my spouse relocates without my consent? It's complicated, but let's unpack this. Federal law introduces the Parental Kidnapping Prevention Act, PKPA, a game changer in child custody cases that prioritizes the child's home state. This prevents forum shopping, where a parent starts legal proceedings in a different state for a better outcome. Even in the context of same-sex marriage, a state that doesn't recognize such marriages is required by the PKPA to enforce child custody orders from a state that does. If you have any questions, call Port and Sava at 516-352-2999 for a free 15-minute telephone consultation.